Good afternoon, everyone. Welcome to the legal reasoning analysis of the Clat 2020 paper. We've done a preliminary analysis as soon as the paper was done yesterday, but today we shall be looking at the paper in more detail and pointing out what were the questions that were problematic, what were the questions that can be challenged. So without much further ado, let's start the analysis. Before we go into the paper itself, let's look at an overall picture of the paper. Now, this is common. There were 8 passages, 39 questions. The length of the passages was not uniform. A few passages were longer than the other, uh, but most of them were of the equal length. All right. When we took a feedback from our students and when we did the analysis ourselves, we realized that the difficulty level of the questions ranged from being easy to moderate. There were not a lot of questions which were extremely tricky or very difficult, but they required, or some questions required, an extra application of either your reasoning skills or at some points even a bit of a legal knowledge. All right, so what are the kind of questions that were asked? Now we've tried to identify 3 broad categories over here. One is inference-based questions. Now, the inference-based questions are those which do not require you to apply a legal situation to a factual assertion made in the question, but rather derive something that is being stated in the passage. For example, an example that we've extracted over here is a statement such as based on the author's argument. So there were at least 1 or 2 questions which required you to mark an option as correct or incorrect based on what the author has argued. So it was not only an application based questions, or there were not only application based options, but also something of this nature. Assertion reasoning used to be a very popular question that used to be asked in the NLU Delhi paper or the ALIT. There was a question of that nature in this paper also. Then something like which of the following is justified, which of the following is true. So all of these questions required you to not only apply legal provisions, but also apply your reasoning skills in order to arrive at an answer on the basis of what has been argued in the passage presented to you. Application-based are your regular questions in which you're required to apply what has been stated in the passage to a factual situation that is asked in those specific questions. And then lastly, legal knowledge. Now, we'll come to what the exact mandate of the consortiums over the syllabus was, but legal knowledge was commonly thought of as not being an area where the consortium would have tested you. There were a few questions which were directly legal knowledge based, such as where they had asked you about defamation, whether it is a civil offense or a criminal offense or both. So that definitely required some level of knowledge of that offense, which means basically that it is not as if you could not go into the paper not knowing anything about law of torts or the law of defamation. And apart from that, we will discuss a few more questions where we thought that some level of legal knowledge was required to answer those questions. All right, now the sample papers by the consortium. The sample papers 1, 2, and 3 that were sent out by the consortium. The current paper that came, the 2020 Clat paper that came, was a bit different from, or at least the legal reasoning section of those papers, of this paper was quite different from what was presented. What was it different on? First of all, on the basis of legal knowledge. In the sample paper 3 that was released by the Clat consortium, all the questions were mostly application of the legal principles to the factual situation presented in the question. But in this paper that we saw yesterday, there were significant questions where you were asked to draw inferences, where you were asked to, or you were required to apply some amount of legal knowledge. So we'll come to those specifics. Let's move ahead. Passage topics. Now, passage topics were mostly current. So something like impact of COVID-19, the styrene gas leak case, mob lynching case, the FIRs against Arnab Goswami and the order of the Supreme Court. All of these issues were extremely current. So yes, they were current issues, but something like principles of natural justice, obscenity, common intention, similar intention, and ex post facto laws were more, uh, if I can use the word, theoretical topics, because it did not require you to have a knowledge of what is happening around you, but something which is like a theoretical topic of which you're required to read a certain passage. Now, the ones that we have marked as a star is just to point it out again and stress that passages on these topics have been given in CP mocks time and again, especially something like the impact of COVID-19 on contractual arrangements has been stressed in a lot of mocks that we have uh, been authoring, especially the legal section. The styrene gas leak case, the ex post facto laws, common intention, similar intention, if not exactly in the mocks. Styrene gas leak case, there was a passage in the mocks itself, but common intention and ex post facto laws are both topics that have been tested enough in at least a practice tests, if not a mock tests. So a fair expectation of the topics that came, and sort of an anticipation from our side of the kind of topics that could be potentially tested in the Clat exam. All right, so let's look at the areas of law that were tested. So they have not left out any area of law. Unlike ALIT, where constitutional law was not really tested in the principal reasoning based questions, you had contracts over here, you had law of torts, criminal law, constitutional law, administrative law, and of course, then we had contemporary legal topics, which could not be categorized into one area of law. So they've distributed the questions fairly across all areas of law that are generally expected to be in a law entrance test paper. We pointed out what kind of passage corresponded to what area of law tested in the paper. Let's move ahead. Before going into the question paper itself, let's just take a step back and look at what exactly was supposed to be in the syllabus of the legal reasoning section of the Clat paper. Now, the screenshot that you see over here is something from the Clat website itself. And I would like to point out the underlined line in red in the screenshot. It is stated over here very clearly and in unequivocal terms that you will not require any prior knowledge of law. However, what is stated in the next line is that you will benefit from a general awareness of contemporary legal and moral issues. So what it means is that although you're not required to know provisions of law, but if there is some legal issue that is being in news, that has been being discussed either in the media or in the newspapers, wherever, and you have a general legal awareness of it, then it will be a benefit to you while attempting these answers. Now it is our time to see whether the consortium has exactly kind of uh, promised or kept its promise as far as this assertion over here is concerned. And I'm thankful to my legal team for having pointed out this source where the Clat consortium itself had laid down its syllabus. So it is time to go down to the specifics and look at the paper. So what we will be doing over here, I'll just stop sharing this screen over here and start sharing the paper itself. So our attempt in looking at the paper will be to first of all look at those questions which we think have problematic answers, and then look at those questions where there could have been a certain amount of difficulty in arriving at one option over the other, and we will try to guide you as to why this option is better than the other option, or if you cannot really figure out which option is the correct answer. Now, the two questions that we have identified as being incorrect, rather, in terms of the answers that have been released by the Clat consortium last evening of the paper that was conducted yesterday. The first problem that we've identified is in the first passage on the COVID-19's impact on contractual arrangements. Let's look at question number 69. All right, so question 69 is relating to a factual situation, question 68 itself. Question 69 is that in the same factual situation as mentioned in question 68, suppose that there is a modification, that there is a force majeure clause in the contract between A and B, and that B, who was to supply goods to A on certain date and time, faced issues in relation to procurement of goods due to mill strike and also because of rise in price of goods. In this case, can B claim the suspension of performance of contract on the basis of the force majeure clause? Now, over here, what we need to know is that do these events that have been described in the question, that is of a mill strike and of the rise in price of goods, can they be classified as something that are or some that fall within the force majeure event? So then let's look at the passage. Can this be sourced from the passage? The passage over here tells us as to what is a force majeure. Now over here, let's look at this. Okay, so it tells us that provisions of force majeure often cover natural disasters like hurricanes, floods, and earthquakes as acts of God. Other events may include war, terrorism, civil disorder, fire, disease, medical epidemics, or by reasons of applicable law or laws or regulations. So if we were to squarely go by this understanding of force majeure and what is covered under the provisions of force majeure, we could have arrived at the answer that the consortium has also released. But there is a further complication to that answer. If we go down and look at the last few lines of this passage, it tells us that certain contracts, let's look at these few lines of the passage. It tells us that certain contracts may state that if a force majeure clause is applied, the contract may automatically be terminated. However, then it goes on to give you an alternative situation. But it also tells us there cannot be a one-size-fits-all solution to this question, and it depends upon how the force majeure clause is worded in a specific contract. And in the absence of the same, applicable laws related to the same will be required to be taken into consideration. So over here, we do not have a situation where the force majeure clause is absent. That was there in the previous question. So that's why the answer to that was that the Indian Contract Act would apply. But in 69th question, we have a force majeure clause in our presence. So what does that mean? This means that although there is a certain understanding of what kind of events fall under force majeure, however, the passage also stresses upon the fact that there cannot be a one-size-fits-all solution, and it depends upon how the force majeure clause is worded. So on the basis of this information, we believe that the answer to question number 69 should not be B, because what does B state? B states that such situation cannot be covered in the force majeure, as it is just a case of disappointed expectations, and hence B cannot invoke the clause. It is merely a case of commercial hardship. Now, the assertion in option B, of course, is not something that can be exactly founded in the passage. However, the option A is something that speaks to the nature of a force majeure clause, right? And what is stressed upon in the last few lines of the paragraph. So for that reason, we believe that question number 69, the correct answer should not be B, and that this question should definitely be challenged, and its correctness or the correctness of its answer should definitely be challenged. All right, now let's look at some other problem questions that we thought were problematic. For that, I'd go straight to question number 103, which is one of the last few questions of the paper. And then we'll come down to a few problematic questions, which might not be incorrect, but required some labor. So question number 103 formed a part of the passage on Article 20, Clause 1, which is the prohibition on ex post facto laws. So it is squarely told to us that Article 20, Clause 1 provides protection only in the case where some law declares an act to be an offense after it has been created or after it has been committed. So in that context, we also have that a law which enhances the punishment or penalty for an offense subsequent to the commission of that offense is also something that Article 20, Clause 1 provides protection against. Now let's look at question number 103. Now question 103 tells us that A is a student of law, he's socially active, expresses his opinion on every social and political event, etc., etc. He severely criticized the policy of the state government. He also stated that the government is biased towards a particular region. Now this blog post was put up on 19th April 2020. And subsequently, the amendment that was made in the IPC, now this is where the things get a bit murky. It says that the blog was posted on 19th April 2020. Subsequently, an amendment was made to the Indian Penal Code whereby hate speech was made a distinct offense and punishment was prescribed. An action was brought against him under the said provision for the blog. Now choose the most appropriate option amongst the following. Now, a lot of people might have had some difficulty over here saying that it is only after Mr. A has put up whatever he has put up on the blog, that is on 19th April 2020. It is after 19th April 2020 that the amendment has been made to the IPC. But the wording of this question is a bit tricky, where it says that was made a distinct offense. So this is sought to be contrasted from it being a new offense. So when we say that something was made a distinct offense, it means that it was already understood to be a part of a larger offense, but right now it has been extracted from there and made into a separate offense. So as far as the assertion in the passage is concerned, where new laws cannot come into place and penalize something or penalize someone for having done an act which was done before that act came into place. But despite all of that, even if you were to look at the correct answer, which says that Mr. A may be liable for the offense of hate speech as the blog was not removed after the amendment, the fact that the blog was not removed, there is nothing in the factual matrix which suggests to us or which tells us that Mr. A's blog was not removed after the amendment. So the option A is suggesting something which is not at all derivable from the contents of the question 103. The removal of the blog is not referred to in the question, so it is difficult for a candidate to then assume that Mr. A would not have removed, because that is the basis for him being made liable for that offense. So 69 and 103 are definite challenges to are definite challenges that you should be making to the consortium and telling them that 69 and 103 should be either struck off or marked as wrong, or whatever the consortium wants to do with it. Now, after having called upon 69 and 103, let's look at a few other questions which were a bit unusual or a bit surprising. So what can also be said apart from these questions not being very tough is that the legal reasoning section was a bit surprising in the sense the nature of questions that were asked. So let's look at the passage on mob lynching. Now, this is the passage that I'm referring to, the mob lynching, which is again a contemporary legal issue. But the kind of information that is provided to you in this passage on pages 27 and 28 are extremely factual in nature. There is no legal provision that is mentioned in these lines. There is no legal theory that is mentioned in these lines. There is no judgment mentioned in these lines. So it is like a news report, which tells you as to what happened on this day when these people were lynched. All right. And it makes no value judgment about it. There is no assertion which can even help you to make a value judgment about the factual situation presented to you in this passage. So in this context, if you look at the questions that are there then. Now questions 86 and 87, it says that which of the following statements given below justifies the criminalization of mob lynching? Now, okay, this question could have been arrived, or the answer to this question could have been arrived at by mere elimination, or rather by an application of common sense and a bit of critical reasoning, rather than application of anything legal or anything law related, because there is nothing legal or law related given to you in the passage above. The passage only has facts. So in that context, if you look at the options over here, you will be required to deploy some amount of common sense, because A, B, C are apparently wrong. I mean, you know that these assertions are wrong. That's why you mark the correct answer as D. So there is nothing wrong with the answer over here. The only thing that we are trying to say is that there was no application of legal reasoning skills over here. It was rather an application of general reasoning skills and possibly some amount of social and political awareness that you're required to have with respect to, is mob lynching an activity that is looked down upon? So that is the common understanding that, of course, mob lynching is an activity that should be looked down upon. So in that respect, the efforts of the consortium are appreciated, that they were trying to bring about a passage which squarely, or were trying to look for these answers which looked down upon the practice of mob lynching. Again, question number 87 was not again a direct question that you could have arrived at by looking at the contents of the passage. Again, something that you were required to exercise your reasoning skills and arrive at the answer. All right. Now, in from questions number 88 to 90, over here is when you over here you're required to exercise some level of knowledge. Okay, so it tells us that the above passage states about the existence of rumors in the area regarding the thieves and dacoits robbing the villagers or committing child lifting. In the light of this proposition, which of the following statement is correct? Now, whether the villagers should be punished or not. Now, again, over here, you are being required to exercise a level of judgment without being given any sort of legal provision. So when do you make a judgment? You make a judgment when you can apply a certain set of principles to a factual situation. Over here, you are given the factual situation, but there are no principles that are given to you. So again, over here, you are required to apply some inherent judgment faculties of your own, which can only be honed if you have some amount of legal awareness. So I think the consortium was trying to stress upon that portion of the syllabus where they said that some amount of contemporary or legal knowledge will be beneficial to the candidate. So in that respect over here, that's why the answer to question number 88 is told as C, that the villagers should be punished, as no individual in the country is entitled to take law in his own hand and punish the wrongdoer. So again, an answer that might not be exactly derivable from the passage, but is something that you are required to just mark off because it is the correct answer. It seems to be the correct answer. Similarly for 89 and 90, 89 of course again is applies the same amount of reasoning skills that have been so forth being seen in all the questions from 88, from 86 to 89. Now again 90, this is an assertion reason question that I was talking about, which is mostly seen in the A-Lit papers. But if you see over here, the reason religious sentiments and feelings are of paramount consideration for the state and should not be interfered with. So how do you know this? You know this because ideally speaking, in a secular country and a constitution which declares the country to be a secular country, the state should not have any role in religion, and especially in the nature it is being told to you in the reason. So again, this was again a manifestation of the consortium's idea of contemporary legal awareness and legal issues which are currently being talked about in the country. All right, so passage over here was of not much use. Like frankly speaking, the passage could not have been there and you could have still answered these questions because the passage had no legal principle in it that you were required to apply to the questions stated underneath. Now, having said this, this passage was particularly, for the lack of a better word, peculiar. Now, why so? Let's look at the question. So what does the passage tell you? The passage merely tells you about the Supreme Court not, basically the Supreme Court refusing to transfer to CBI the criminal cases lodged against Mr. Arnab Goswami and the quashing of all FIRs except one, which was retained in the Bombay, which was basically transferred to the Bombay jurisdiction. And then you have a discussion about how the freedom of speech and expression, and particularly when it comes to media, should not be curbed because media persons are the ones who speak truth to power. And then you have this entire quote over here: questions you cannot answer are usually far better for you than answers you cannot question. Something that is quoted in one of the questions below. So let's look at the passage. Let's look at the questions over here. Now from 91 to 95, the questions that form a part of this passage, 91 and 93, 91, 92 and 94. These are questions which were a bit confusing and a bit tricky, if I may be allowed to say that. In the 91st question, first of all, the question is asking you that what could be the appropriate reason for such a request. So it is asking you to imagine a reason which you cannot directly source from the passage, because the passage again is not so big on why the case was transferred or why the request to the CBI was being made. It is just told that the Supreme Court refused to transfer the case to CBI, and the order of the Supreme Court that is quoted in the passage merely refers to the exercise of the fundamental right of speech and expression, and what does Article 32 allow the Supreme Court to do in such a situation. So the correct answer to question number 91 is given as B. But over here, in stating that the correct answer in question number 91 is B, you are required to assume two things. First of all is that the state government is an interested party in that case. So in this entire, in the answer to question number 91, or in order to arrive at the correct answer to question number 91, you are required to assume two things. First of all, that what is the role of the CBI, correct? Second is that in case the state government is invested or is an interested party, which again, you do not have the means to arrive at looking at the contents of the passage. So you would only know that the reason why a case is transferred to the CBI is when the state government is an interested party is something that you are required to be aware about. So this entire sort of a facade that legal knowledge is not a big thing or legal knowledge is not something that you're required to be aware about is broken, because over here you're required to be aware about two things. First of all, that when there is a state government which is an interested party, which it was in this present case, that is the state of Maharashtra, over here, which is not told to you in the passage, but you're required to be aware about, in such situations, the investigation can be biased. And secondly, that the CBI is the authority which is the relevant authority to investigate into matters where the possibility of a state government being biased is high. So that's why the correct answer though is correct, but the only point that we are trying to make is the fact that this question could not have been answered on a mere reading of the passage. Now, question number 92. Again, there's a tiny mistake in this quotation that they've put out, that questions you cannot answer are better than questions you cannot question. It should be questions you cannot answer are better than answers you cannot question, because it is lifted from the passage itself. So that's a typographical error. Ignoring that, if you were to ignore that and just apply what has been stated in the passage, it is asking us what describes the scope of such questions. Now, in saying that the correct answer is D, over here, what assumptions are being made? The assumption that is being made is, first of all, that the candidate knows that fundamental rights can be subject to certain number of limitations. All right, that is the first assumption that the maybe the consortium papers setters have made. First is that the candidate is aware about the fact that there can be certain limitations imposed upon the exercise of fundamental rights. And second, that even the exercise of asking questions is an exercise of a person's fundamental right. So since an exercise of asking questions, specifically in the situation where there are media people and journalists who constantly question authorities in power, those exercise of questions, or those exercise of asking questions is also an exercise in their freedom of speech and expression. And because it is an exercise in freedom of speech and expression, it can be subject to some limitations, because no freedom of speech and expression or no fundamental right is absolute in nature. So D option is correct, because it states that the questions are also subject to limitations imposed upon the freedom of speech and expression. So let's quickly look at the passage, and let's see whether the passage over here told us that the fundamental right contained in Article 19(1)(a) is something that can be subject to a limitation. So on a plain reading, it does not suggest something like that. It states that the exercise of journalistic freedom lies at the core of speech and expression protected by Article 19(1)(a). Airing of views which he hosts is in the exercise of fundamental right to speech and expression under Article 19(1)(a). India's freedoms will rest safe as long as journalists can speak truth to power. And then you have the quote which is asked in the question. So the passage was not big on telling you that there can be certain limitations on a person's fundamental right of speech and expression. But again, the fact that fundamental rights are not absolute in nature are something that is probably considered common knowledge now. So because of those reasons, the correct answer to question number 92 has been posed as D. Let's look at question number 94. Question number 94 over here again required you to at least know the concept behind or know the reason why multiple FIRs is something that is considered bad in law. Why is it considered bad in law? Because multiple FIRs can lead to multiple investigations, which can cause hardships to the accused. So option A is actually quite bang on point, but again, nothing to source it from the passage. 94 B and C could have been eliminated on the very go or looking at those options itself, because first of all, B has no basis. C says that C again has no basis because uh, uh, it does not seem to be logically flowing from the contents of the passage. The confusion could have been between options A and D, and the consortium has gone for the answer as A because that makes more sense legally speaking over D, which is not worded in a language which is more logical and meaningful in option A. Okay, but again, this was a question which required you to have some amount of, if not exact legal knowledge, but some amount of legal awareness. So there seems to be a very thin line between legal awareness and legal knowledge, which this paper is treading on, sometimes falling onto either side. Uh, but question number 95 is a perfect example of you being aware about something such as defamation is punishable as what. So this, you could not have been aware as to the nature of punishment of defamation had you not read about defamation or defamation as a tort and defamation as a crime. Uh, so that's why the correct answer to this is A, and this required you to have the knowledge about the offense of defamation. So people who have been attending coaching classes, people who have been uh, brushing themselves upon the legal knowledge would have found this question easy to answer, but some might have found it confusing because they might not have known the exact nature of the offense of defamation. All right, so that brings us to an end of the tricky and the problematic questions that were present in the paper. If I could go back to my presentation, just give me a minute. We've discussed the specifics. Now let's look at the numbers. So you had a total number of 39 questions in the paper. The problem questions that I've marked out are 69, 103, 91, and 94, of which 69 and 103 marked as an asterisk we are saying have wrong answers and they should definitely be challenged. 91 and 94 are marked over here as being questions that require you to exercise some amount of prior legal knowledge, if not exactly derivable from the contents of the passage. Tricky or confusing are the questions on mob lynching, because these questions were not the ones that you could have arrived at an answer right by looking at the passage itself. You were required to have some amount of social legal awareness about the issue of mob lynching and about the idea of a democratic India where decisions are not taken by a whim of the majority, but by a proper exercise of rule of law. All right, so 86 to 90 fell in that category, if not wrong, but somewhat vague when it comes to the contents of the passage. Legal knowledge based 73, 95, and 100. 100 was the question on common intention and similar intention. 95 was the question on defamation. And 73 was the question where obscenity, the passage on obscenity, where it was asked that under what category of fundamental rights can you say that obscenity falls under? The question being that the issue of obscenity is fundamentally related with which of the following, right? So the correct answer was freedom of speech and expression. So this was not exactly legal knowledge, but it was something that you could have arrived at by looking at the contents of the passage, but knowing that what exactly is contemplated within freedom of speech and expression. All right. So again, the same thing, treading on a thin line between legal awareness and legal knowledge, in which the legal awareness is something that you are required to have when it comes to the CLAT exam, but legal knowledge not so much. So having taken all of that into consideration, having looked at the problematic questions and the tricky questions that people could have spent considerable time at in solving, we've arrived at a good attempt being at least 30 and above for the legal reasoning section. How have we come at 30? Because if you add up all these numbers over here, exclude the legal knowledge based questions because they might have been easy. If you add up the numbers that are stated in the first two rows, that is 1, 2, 3, 4, 63, sorry, 69, 103, 91, and 94, and the 5 questions over here, they come out to 9. So if you 9 were the ones where the fate of people lies, where in which college they will make it to, if people get those questions right. But 30 plus questions should be good for you to get into a decent college, at least if you scored, correspondingly well in other sections also. So that is the analysis of the paper. What are the key learnings for us? Let's say someone who is watching this is going to be writing the Clat exam in 2021. What are the key learnings for a Clat aspirant for the next year? First is that legal knowledge is not completely out of the picture. Although it is the reason why the pattern of the Clat was changed and why passages were included in the legal reasoning section also was to supply you with all legal information that would be necessary for you to answer a question in that section. But it seems that there were certain questions in this paper which require to exercise some pre-existing knowledge, specifically like the question on defamation being both a civil and criminal offense, the question on fundamental rights and the limitations that can be imposed on them, and whether a question that is asked can also be a part of that, which was in the Arnab Goswami case. The question on common and similar intention, the second last question on common and similar intention, the difference that was asked. So legal knowledge is not completely out of the picture. So it is important for you to brush up your basic legal concepts. The concepts tested were not very high funda. That much I can definitely say. The concepts tested were not very high funda, but the very fact that they did test on some prior existing legal knowledge is very telling of possibly the next paper. Let's see how it pans out. Critical reasoning skills are also to be employed, which means that you cannot leave your critical reasoning section and leave your critical reasoning skills at the critical reasoning section. You need to transport them to a legal reasoning section also, because the questions on mob lynching specifically did not require you to look at the passage at all. You're required to bring into your answers your skills of reasoning, your skills of critical and analytical reasoning to arrive at the correct answer. And a habit of reading is essential. So without having some amount of proficiency in reading and comprehending, analyzing, and coming to a quick answer within the same time is essential for the Clat paper. This was a lengthy paper. If you look at all the sections combined, I think the total number of words in this section together were 19,000. So that's almost like a thesis. So a habit of reading is essential. So people who are going to be preparing for Clat 2021, start looking at passages, start looking at reading, start looking at legal articles, go to the websites of Wire, Quint, Scroll, where you will be able to find passages specifically on legal issues, where then you can develop the habit of reading such passages. So these are a few key learnings from this Clat 2020 paper. So all the best for your results that can come out soon. Do remember to challenge the questions that we stressed upon. And if you feel there are more questions that on looking at the analysis of this paper that you felt can be challenged, please go ahead and challenge that. So thank you for tuning in, everyone. With that, we've come to an end of the analysis of the legal reasoning section.